Hey there, welcome to TGM's Legal Nuggets, where knowledge meets inspiration. If you're looking for insightful content that informs, empowers, and transforms, this is the place to be. Don't miss out. Hit the subscribe button now and turn on notifications. Join the community and let us grow together. See you inside. The political turmoil in Rivers State has escalated into a constitutional crisis, pitting former governor and current FCT Minister Nyesom Wike against his successor, Governor Siminalayi Fubara. Now, this conflict has led to a state of emergency declaration, suspension of the governor and state lawmakers, and the appointment of a sole administrator. This analysis we're about to do examines the legal position of both parties, the constitutional implication and potential resolution of the issue at stake or the issues at stake. Welcome again to TGM's Legal Nuggets, where we talk on societal issues and dissect them, giving legal perspective to these issues. We want to thank you for your support, for your contribution, subscribing to our YouTube channel, Soteria-Television or Soteria TV, and for following us on Facebook, on Instagram, and likewise on TikTok. Now, today we want to consider a very important topic, and that topic is the Rivers State political crisis, Wike versus Fubara. That's what we want to talk about today. Of course, a whole lot of people are aware of what is going on, but of course, we want to give some legal insight into the topic for today. Now, what is the background of this crisis? Now, this discord between Wike and Fubara centers on, control over Rivers State's political and structural resources. Now, Wike has actually expressed willingness to reconcile if Fubara sincerely seeks forgiveness. However, he also revealed that he initially sought Fubara's removal, but President Tinubu's declaration of a state of emergency prevented that implosion, or prevented the state's implosion, as you may want to, put it. Now, the question is, what are the resources that are in Rivers State that Wike and Fubara are actually grappling over? That's a question you might want to answer. Yes. Now, with respect to this issue and what has actually been unraveling, what is the legal position of the law? Now, for Governor Fubara, constitutionally has the mandate of the people to govern. Now, as an elected governor, Fubara's tenure is protected, quite alright, under Section 180 of the Nigerian Constitution 1999 as amended. Now, that particular section stipulates a 4-year term unless he is removed by way of an impeachment or by resignation. Then again, should we say that the suspension was legal? We need to talk about the suspension, the legality of the suspension and so on and so forth. The suspension of an elected governor raises serious constitutional concerns. Of course, the Nigerian Bar Association actually has criticized the move as illegal, emphasizing that a state of emergency does not dissolve elected government. But again, you might want to put that in contrast to the powers granted by the Constitution to the president to declare a state of emergency. We've actually done a video before on this topic, and we want you to go back to our YouTube channel where we have full clips of our videos so that you can get our perspective on this issue. Now, on the part of Wike, should we say he is legally backed with respect to his demands in Rivers State? Now, we would say that for Wike's part, there is what we might term political influence. Yes, Wike's demand for Fubara's apology and his role in the political dynamics suggests a significant influence. Of course, you can't rule that out. Now, that influence covers affairs of the state, and that raises serious questions about the boundaries of political mentorship and interference. Of course, Governor Wike on several fora and interviews has actually come out to say that as of the time he would be stepping out of office, he wouldn't interfere with the government or the governance of the state. But again, you want to ask the question, why is our dear Mr. Man, interfering with what's going on in Rivers State? Then again, legitimacy of assembly members. We remember we're talking about Wike's angle now. Now, the Supreme Court actually clarified that there was no evidence of defection by the 27 lawmakers who are, purportedly loyal to Wike, which implies that as of the time the judgment was given, they are still members of the State House of Assembly and they never, in fact, defected. But again, if you go over to social media and other conventional media platforms, you would see where members of the House were granting interviews and celebrating and stating that they've actually, in fact, defected, to another political party. But again, the courts do not rely on social media evidence. It is the evidence that is presented before the court that the court would rely on. So if there is an overwhelming evidence in public domain and that overwhelming evidence is not brought to the attention of the court such that the court needs to, scrutinize it and declare it as admissible such that the court can rely on it to give its verdict, then no matter the amount of evidences that are out there which are not brought to the attention of the court will not be bound to rely on those evidences. So that is one thing we must understand. So it is the evidence you bring before the court that the court will consider to give its verdict. Now, with respect to what is going on, what is the constitutional implication for the states? Rivers State which is the state in question now. Of course, we already know that there is a state of emergency declaration. Now, under Section 305 of the Constitution, the President can declare a state of emergency, like I've stated before, in specific circumstances. However, the suspension of elected officials during such a declaration is something that is really, really contentious and may be deemed unconstitutional. Remember, we've actually done a video on this before. We want you to go back there to see our analysis on that particular video. So go to our YouTube channel, Soteria-Television or Soteria TV, to get our insight on that particular topic. Then again, you need to talk about legislative defections. What does the Constitution say about this? Actually, Section 109, subsection 1G of the Constitution states that a lawmaker's seat becomes vacant if they defect from the party on whose platform they were elected. Now, it's settled unless there is a division within the party. And that's a caveat. So, the court's dismissal of the suit against the 27 lawmakers suggests a lack of sufficient evidence of defection, of course, which I've stated before. If you have evidences, you need to timeously bring it to the attention of the courts, so that the court can actually construe, interpret, and be bound to rely on such evidences. Again, do we have historical precedents of situations like this in Nigeria? Yes, Plateau State 2006, a state of emergency was declared and the governor was suspended due to political unrest. Again, in Ekiti State in 2006, similar measures were taken following a political crisis. Now, these instances actually highlight the federal government's intervention in state matters. Remember, Nigeria practices a federal system of government, which can also be termed as a presidential system of government. Remember, both are different, but Nigeria practices a presidential and a federal system of government. However, the legality and constitutionality of such action remains something that will continue to spark debates within Nigeria. Now, given the prevalence of political crises, the role of godfatherism and all that within the Nigerian political space, what are some of the solutions that can be proffered that would bring about lasting solution to some of this. Now, number one, there has to be a serious judicial review. Courts should actually expedite hearings on the legality of the state of emergency and the suspension of elected officials to restore constitutional order in the state. Yes, such matters should be treated as a matter of urgency and should be determined timeously in order to correct whatever political error that is actually going on within the state. Now, again, there has to be political reconciliation. Mediated dialogue between Wike and Fubara could actually de-escalate tension and promote governance stability. However, in this case, there has been several instances where stakeholders within the state and outside the state actually waded into the issue to try to see how they could provide solutions to the lingering problem between Wike and Fubara. However, to the best of our knowledge, that has not yielded any good results. And it has actually increased the tension in Rivers State. In fact, currently, recently, over the past week, there's been series of protests and marches and all that in Rivers State. And something needs to be done as a matter of urgency. Again, there has to be legislative clarity. Now, clear guidance on party defections and their implications should be established to prevent future disputes. Because I bet you, in Nigeria, you would continue to see, defection from one political party to another political party. Currently, in Delta State, the senators in Delta South senatorial districts have actually defected from the People's Democratic Party to the APC. So this implies that this is not something that's going to stop anytime soon. Politicians would continue to defect from one party to another. Then again, there has to be serious public engagement. Civil society organizations should actually advocate for the adherence to constitutional provisions and democratic principles. Democratic principles are, dished out as a matter of theory. In terms of practicality, we've not seen the effect in our political space, and I think civil society organizations need to do more in trying to sensitize politicians, the citizenry, and all and sundry to be abreast of the core of being involved in politics within a political space. Now, the Rivers State crisis underscores the delicate balance between political influence and constitutional governance. You understand? Now, upholding the rule of law is paramount to ensuring democratic integrity and preventing the erosion of public trust in Nigeria's political institution. Okay, wait. If you actually have enjoyed our legal nugget up to this stage, why don't you go over now to our YouTube channel, Soteria-Television, Soteria TV, subscribe, click the notification bell, like, share, comment, go over to Facebook, follow us, TGM Amwero Esquire, and also on TikTok, TGM Amwero Esquire, and also on Instagram, Soteria_TV. We're actually here to bring you insights on societal issues, giving you the legal perspective to these issues. And now, to sum it all, we actually kick against godfatherism. If a governor is done serving in a particular state, he should wash his hands off the governance of that particular state, except he has a legitimate interest, legitimate in quote, which has been infringed upon and which he hopes to be corrected. And in that particular instance, he should resort to the use of the court of law to be able to correct that instance. Whatsoever agreement that cannot be codified, that cannot be brought within public light, and is not in tune with prevailing laws in Nigeria is not a legal agreement and should not be talked about. Now, politics is not outside the province of the law. Politics is within the province of the law. Whatsoever agreement that is reached must be reached within the province of the law and should be enforced within the law. If such agreement cannot be enforced by the law, it therefore means that such an agreement is illegal ab initio. And I think as Nigerian politicians, we should begin to take a look at these issues and try to see how we can bring an end to unenforceable agreements that are reached with political stalwarts before any election. So we thank you for being there. This is our legal nuggets for today. We'll see you again in our next video. Keep in touch. Keep liking, sharing, engaging on our comments. See you again. Bye-bye.